Next is the matter of David Spade versus Select Comfort Corporation and Christopher Wenger versus Bob's Discount Furniture. If council could please step forward. An enviable position of batting cleanup after a lengthy argument. Welcome back.
My name is David Kott. I'm a lawyer with McCarter in English, and I represent the Amicus Curiae New Jersey Business and Industry Association, which is the largest business trade association in New Jersey with over 19,000 members. Chief Justice Radner, I'll accept your offer to clean up. And I'll come right to a question you posed to counsel, and that is essentially tell me about the amendment to the statute. And I think that amendment is important, and I think it actually supports the positions of the defendants here. Because what that amendment did was it did two things. It changed the word damages to the word penalty. That's one thing it did. The second thing is it left in the word aggrieved. So now what the statute provides for on the $100 is not damages. It is a penalty. And I've addressed before with this court the constitutionality of TCCWNA under BMW Gore, under State Farm Campbell, due process violations, because there is no proportionality and because of the lack of reprehensibility. Here we're talking about incorrect font size. There's also equal protection issues and dormant clause, commerce clause issues. But penalty adds the Eighth Amendment, the prohibition on excessive fines. So I think that's significant to this analysis, and that's the reason why this court has said consumer protection statutes are liberally construed to effectuate the remedial purpose. However, this court has also said when we analyze statutory penalties, we analyze them narrowly. And the court has actually said if we have a statute that has both, some aspects might be liberally construed, but the penalty will be narrowly construed. I don't think you need to get there, because I don't think with a normal construction we have any question what aggrieved means. But if any of you have a question about that, I think between the constitutional issues and the fact that this court construes penalties narrowly, I think that drives the question home. And of course, if we have an option of interpreting a statute in a way that is constitutional or a way that is unconstitutional, this court has said we will opt to interpret it in the way that's constitutional. One other point. TCCWNA does not have a lot of elements. The plaintiff does not have to prove that the defendant acted with intent. A defendant can be liable for a TCCWNA violation for violating some very obscure federal statute, and there are a lot of federal statutes. A defendant can be liable for some highly technical violation of a federal statute. And the defendant does not have a good faith defense. And now we switch over and we look at the damages available, particularly in the class action context. A TCCWNA class action could easily put a small company out of business. It could even put a very large company out of business. And the proof for that is Dugan. Dugan had a defendant that was a very large company. And that defendant, had this court allowed the class certification to go forward, would have faced damages in excess of $1 billion. And that's before you even get to the consumer fraud damages. That's the TCCWNA damages alone. We know that the legislature, when they enact consumer protection statutes, does a balancing. They balance on the one hand the rights of the consumer, and they balance on the other hand the impact of the legislation on businesses. And that's exactly what they did here when they included the aggrieved requirement. The aggrieved requirement means that a plaintiff who has suffered some adverse effect from the technical violation can recover. But the aggrieved requirement also means that a company will not be subject to a technical class action that might put it out of business when the plaintiff has not suffered any adverse consequences. Justice Patterson, you posed a question to one of the counsel, so what is the standard? And that's why I use the phrase suffered some adverse effect or consequences.
This doesn't require damages.
Does not require damages, not at all. Just some, and I'm careful because the legislature wanted to give a remedy to people who did not have damages. And that's why I use that as the standard. I didn't invent that. This court invented that. In 5 or 6 opinions looking at other statutes that use the word aggrieved, that's how this court defined aggrieved. Suffered some adverse effect or consequences. So Justice Patterson, that's what I would suggest the standard is, and I think that's clear what the legislature intended.
What's the difference between aggrieved and ascertainable loss?
Well, ascertainable loss, the person needs actual money damages. Somebody can be aggrieved, and the court has discussed in colloquy with counsel some situations, some hypotheticals, where the customer, as a matter of law, would have no damages, and therefore would not have an ascertainable loss, but still would be aggrieved because they had suffered an adverse effect of the violation.
Inconvenience.
Inconvenience. I could give you other
Annoyance.
hypotheticals. Annoyance. Could be more than that. I'll give you a hypothetical I thought of, which is mother lives in Patterson and her son is about to attend Eastside, Patterson Eastside. She wants to send him to a private school. She enters into a contract and the private school requires her to pay the entire year's tuition up front, and she's got the money. And then she gets in an accident and she needs $3,000 to repair her car. She no longer has the money to send her son to the private school. She has no damages. In fact, she saved money because she's not paying the tuition. But under any version, that mom, and I'm going to call her a mom, is an aggrieved person because she wanted to send her son to a private school that would be better for him. And I could come up with other examples, but we need to make sure that aggrieved does include people who actually have been harmed. But we need to equally make sure that we don't include an aggrieved people who have had absolutely no harm, none, zero.
Thank you.
Thank you.